Panel members, I had my microphone off. Did you hear me? Thanks, Nimrod. Thank you.
Can you hear me?
Yes.
Is the problem corrected? Is it clear? Because we did everything we could and it indicates at this end that the Wi-Fi is fine.
It says, yeah, you seem to be better than before, but we'll see how we go through the hearing.
Okay.
Anyone who wants to receive a copy of the committee's decision for an application must submit a written request by email to the general email address for the Committee of Adjustment, Toronto and East York District Office. Please include your name, address, and an email address. All Committee of Adjustment and TLAB notifications and appeal updates will be sent by email only. You may not agree with the decision of the committee. Decisions may be appealed to the Toronto Local Appeal Body, TLAB, or in some limited circumstances to the Local Planning Appeal Tribunal, LPAT. Appeal instructions will be set out at the bottom of the committee's decision. Virtual hearing procedure. Participants who have registered in advance will be connected to this virtual hearing. They will be muted automatically upon entry. When the item is called, each participant will be unmuted by the moderator, one person at a time. I will call each item in the order listed on the agenda. Where an application is uncontested, the applicant or agent will proceed with his or her presentation if required by the committee. The committee may ask questions or take the matter directly into committee for a decision. Each speaker, including the applicant or agent, will be allotted a maximum of 5 minutes to address the committee. I will comment when you are approaching the 5-minute mark. When addressing the committee, please speak slowly, clearly state your name, and please confine your remarks to the matters outlined in the application. Where required, the applicant or agent will proceed first with a presentation of the application. Then, individuals, either in support of or in opposition to the application, will be invited to speak. Committee members may ask questions of each speaker after they have completed their presentation. When all speakers are finished, the applicant or agent will be unmuted and will have an opportunity to rebut, but only those issues that were raised by the speakers. And this will mark the end of the discussion. The application will be taken into committee for a decision. Please note, the committee may not entertain revisions to proposals at the hearing today. The committee may decide to defer the application if substantially revised, to ensure the revised application is accurate and that all those entitled to notice are informed of the changes. Madam Deputy Secretary Treasurer, have the minutes of the, I guess we did that this morning. Have the minutes of the last Committee of Adjustment public hearing been confirmed? Did it this morning. Declarations of interest. Panel members, staff, anyone have any interest to declare on any of the items scheduled for this afternoon? Thank you. Madam Deputy Secretary Treasurer, are there any requests to withdraw an application?
Not that I'm aware of, Mr. Chair.
Thank you.
But we do have 2 applications to be deferred this afternoon.
Very good. Let's proceed with those ones first.
So the first one would be item number 25. I don't know if Mr. Goldman, the agent, is available, but he is aware that the application is going to be deferred. The plan of survey filed with the application is not actually a plan of survey, and it appears that some of the variances may be located on city property, so he needs to have a up-to-date survey done and a new zoning review. In addition to the fact that the building was before once a lawful non-conforming variety store in a residential neighborhood, and so I'm not sure if there's other residential standards that now would be applied to that property as well.
Thank you. Okay. Is the applicant with us?
Through you, Mr. Chair, the applicant is not in the
Not
hearing.
with us, okay. Okay, committee members, the applicant's not with us, but for the reasons which the Deputy Secretary Treasurer has just laid out, there is a request to defer here on item 25. So I would look to committee for a motion with respect to defer or not to defer. Mr. Nipfel, please.
Mr. Chairman, I'd like to move a motion to defer this application with circulation fees.
Motion to defer circulation fees to apply. Second on that? Second, Mr. Salomon. Show of hands, all those in favor. The motion is carried and application number 25 is deferred. Deferral fees to apply. Thank you.
And then through you, Mr. Chair, the last one is item 32, 130 and 132 Sears Street. This is a consent that lapsed, and in the processing of the notice of public hearing, there were some irregularities and improper notice went out, so we need to redo the notice, and also there was previous C of A decisions were referenced, but it should have actually been an LPAT OMB decision, I believe.
I see, okay. Thank you. Is that applicant with us? Once again, committee, on 32, there's a request to defer for the reasons just explained. I'll look for a motion on that one, please. Mr. Salomon.
I'll move deferral of the item, subject to the deferral fees.
Thank you very much. Is there a second? Second, Mr. Nipfel. Show of hands, all those in favor. And the motion to defer is carried unanimously. The application is deferred. Deferral fees to apply. So we now take our attention back to the written agenda, and we are at item number 20, 440 Front Street West. On this application, the committee has before it the following: applicant's materials, a previous consent by the committee, and there is correspondence from Ann Benedetti, the solicitor, involving Schedule A, colored architectural plans, Schedule B, colored plans and GFA chart, and a justification letter. Moderator, is the applicant standing by?
Through you, Mr. Chair, we do have the agent on the line, Heidi Green.
Good afternoon. Good afternoon, Heidi.
There we go. Good afternoon. Hi.
Hi, could you state your name, please?
Of course, Heidi Green. I'm the applicant for the submission.
Thank you very much. Let's check with the panel to see where they stand. Panel members, would you like to hear a presentation on this application? Or do you have questions for Heidi Green? Question, Mr. Salomon.
Yeah. Did the applicant get any comments from community planning?
We did not. Sorry, there was a circulation that they were invited to comment on our application, and from what I understand, they were supportive of our application. And in our talks with them, we were very transparent, and we approached them all along the way, and they never voiced any concerns about this application.
Mr. Nipfel, please.
Could you clarify whether I've got this correct? Part of the change in floor area is the result that you're moving, as I understand it, some bicycle storage from residential to non-residential to meet the needs of a new tenant. Is that correct?
The requirements for the bicycle parking did change, and so we did design for that, I believe, in the second level of Building D. We did include that. Yeah, and that resulted in a reduction of the GFA in general. I think it was 115 square meters of GFA for that.
Okay, thank you very much.
You're welcome.
If there are no further questions, then we could look to Mr. Nipfel.
Mr. Chairman, I think this is a very straightforward application. They're accommodating the needs of some new tenants, and they're making changes as they're leasing up. I don't see that there are any negative implications to the proposal, and I'd like to move approval without conditions.
Thank you. Motion to approve, is there a second? Second, Mr. Chang. Motion to approve before us. All those in favor, show of hands. And the motion is carried unanimously. The application is approved. Thank you. Committee moves to application number 21. 10 Summit Avenue. The materials we're looking at here are those submitted by the applicant. There are renderings of the proposed property and comparables, and there is a report from City Planning. Moderator.
Through you, Mr. Chair, we have no speakers in opposition, and the agent, Marco Vieira, is on the line.
Thank you. Good afternoon.
Good afternoon, Mr. Chair, members of the committee. My name is Marco Vieira.
Thanks very much. Panel members, if you would like a presentation, let me know. If you want to go straight to questions, please carry on. And if there are no questions and no presentation requested.
Through you, Mr. Chair, I just want to make sure that the members are aware that the purpose of the application should be a 4-story detached duplex. The variance is correct. It was just not stated the same.
Right. Yeah. In fact, I do have a question on this one myself for the applicant. So you are requesting 4 stories, where 3 is the permitted number. I'm specifically concerned because of that, the nature of that street and this lot. I'm wondering about the impact of your proposal on 476 McRoberts. This is directly sort of down the hill from your property. Has that owner, have you had any discussions with that owner?
Hi, Mr. Chair. Through you, Mr. Chair, we have not. We know that the owner has approached my client, explaining to them what our scope of work is. The existing lot at 10 Summit has a really increased change in elevation. So from the west side to the east side, there is a 5.5 meter drop. 476 sits approximately 1.2 meters lower. So with the number of stories is as a result of the basement being counted. And because established grade and also average grade, which is measured differently from one bylaw and the other, that basement area is now counted as a story. And that is because simply of the existing sloping of the site. The building, as of right, is only on the east side, 11.4 meters in height, but in the western limit of the property, it's actually below the allowed height permitted. And I did include a visual of the site profile to show the relationship of our proposed building to the adjacent properties. So that change in elevation is quite significant from west to east along the property line. So that's
Is this the
the
rendering you're
visual you
talking about?
see. Yes, it is. So this visual here, it's an image of the elevation from the street to scale of the existing two dwellings on our west side, so at the back of our lot. Then the one on the right is our proposed building. You can see that this particular elevation, the slope is more on this side than it is on the north side along the property line of 476. We've retained that existing slope on that side, minimize the impact to that adjacent property. So that's why the front looks higher than the back. The back is significantly shorter, let's say, where the back of the building we're at 10 meters, but at the front of the building we're basically 11.8 meters at the lowest point. And that's why we have that increase in GFA and also the increase in height, the result average of the sloping.
Thank you. Mr. Solomon?
I had a question for the applicant. The community planning's comments were that approval be tied to the plans. Did the applicant have any issue with that?
No, we do not. We did discuss our proposal. We went through the variances. We also double checked with the zoning examiner to make sure we had the correct variances and how the height was being interpreted. We have no objections to being tied to plans.
Thank you. Okay then, if there are no further questions of the applicant, I would look to panel for a motion, please.
Mr. Chairman, could I get a point of clarification?
Please.
I have a memo from community planning that references what Mr. Solomon said, that they it says they will be submitting a report that recommends that the proposal be tied to plans as it relates to height, number of stories, and setbacks. Can I confirm that there wasn't a subsequent report that had other information in it? This is all that we have?
Correct. There is no other report.
To staff, as if there's is that question to put to staff, Mr. Niffel?
Whoever can answer, I just wanted to make sure there isn't another report somewhere with another condition. Mr. Solomon's referring, I think, to the same memo that I am from...
Is it just an email?
Yes, it is, from Celia Wong, saying she will be submitting a report.
They never followed
But
up.
okay, thank you. That answers my question. Thanks very much.
So I'd like to move approval of the requested variances subject to tying it to the plan submitted.
Or just the elevation?
Well, I guess the site plan and the elevation drawings, the site plan would then show the setbacks as well.
Okay, then a motion to approve from Mr. Solomon, tied to site plan and elevations, seconded by Mr. Solomon. Show of hands, all those in favor? Mr. Niffel, sorry. Seconded Mr. Niffel, all those in favor? Thank you. Motion is carried unanimously, and the application is approved, tied to site plan and elevation drawings submitted. Next, we move to agenda item 2234, Howard Crescent. The committee has before it the following: applicant's materials, 3 photographs of the subject property, a context map, 2 drawings of the pool layout and site plan, covering letter from Michael Goldberg, agent, and a previous Committee of Adjustment decision affecting the property. There is a staff report from Community Planning, Toronto East York. And there is written correspondence in the form of 10 form letters signed by owners and occupants at 8, 9, 10, 12, 14 Ardmore, and also 32, 43, 47, 49, and 51 Howarden Crescent. Moderator.
Through you, Mr. Chair, we have the agent on the line, Michael Goldberg.
Hi, good afternoon. Good afternoon. Can everyone hear me okay?
Yes, we do.
Oh, great.
If you would, please just give us your name.
My name is Michael Goldberg. I'm a principal at Goldberg Group, and we are the planning consultants or agent for this application, sir.
Thank you very much. Now, I'm going to check with panel members. Panel members, would we profit on this application from a presentation? Are there any questions for the applicant? Mr. Cheng, please proceed with your questions.
Yes, I just want to go straight forward to the planning staff letter or report regarding the definition of front line or the front of the lawn, which basically would, comment how I want to know how the applicant responding to this, the definition of how this property is situated and how that swimming pool is negatively impacting the overall landscape.
Mr. Goldberg.
Oh, great. I needed to be unmuted. Thank you. Sure. We have put some presentation materials up, and I think some of this visual material responds directly to the question put. I'm wondering if that can be put on the screen, please.
Yes, it can. Just a moment, please.
Okay. Yep, that's very good. Thank you so much. So in the comments from the community planning, under the comments, the second paragraph and the second sentence of the second paragraph is really the nub of the question and the nub of the community planning department comments. And it says the intent of the zoning bylaw provision restricting ancillary structures such as swimming pools from being located in the front yard of a dwelling is to respect the existing streetscape character and landscape open space pattern of the street. So that's really the nub of the planning department's questions. And you can see the subject property is oriented like a rectangle in a north-south direction. From the standpoint of the zoning bylaw, the shorter of, and you can see it's a corner lot, so the shorter lot line abutting the street is deemed to be the front lot line, where the longer one is deemed to be the flankage lot line. If you could turn the page, please. So what you can see is on the left-hand side is Ardmore, and on you can see Hawarden on the right. What happens is the actual front of the house, the driveway, the front door, the effective front yard is not actually next to Ardmore, it's effectively next to Hawarden. So what this lot has, it effectively has a side yard amenity area, an effective side yard amenity area that's technically called a front yard by the bylaw next to Ardmore, and then it has one on the south. But today, the front yard, for all intent and purposes, is the Hawarden frontage. Today, the Ardmore frontage is used for landscaping, but on this image that you see on the screen, it's really like a green wall on all sides of the yard. So when the planning department, and I'm going to show you some more, if you could turn the page, please. So that is the front yard. That is what faces Hawarden. And on the left of the screen, you can see the density of the hedging and the height of the hedging that is next to that north lot line next to Ardmore. Can you turn the page, please? There it is again. So you can see the entrance and the hedging that goes in. That's there today, members of committee. That's going to be there. And behind that gate is where the pool is. So when the planning department expresses concern about respecting the existing streetscape character and landscape open space pattern of the street, the truth is none of that's going to change by this application, because this landscaping is in place today. It forms part of the landscape character of the street. And behind that, within the yard, is where the pool is. So I hope that answers your question from the standpoint of how you determine which is the front yard. In this case, it's a highly technical interpretation of the bylaw, because if you're out there today, you would think the front yard is on Hawarden, and you would think that this is one of the side yard amenities next to Ardmore. But the truth is the bylaw is a blunt technical instrument, and that's how it has been determined. But we're hopeful that you're thinking that when the pool goes behind this landscaping, no one sees in and nobody sees out, and that's the condition today. They use that area today as a side yard or a rear yard amenity area because it is immediately off the kitchen of this particular home, and that is why it's convenient to use as a backyard.
Okay, so a quick follow-up question. I'm trying to look for some drawings showing the elevation of the pool. So there's no structures proposed. Everything is digging underground. I mean, great. Is there any canopies, any pool house?
No, there is not, sir. I think there is a site plan
Right.
that was part of my package, and we're not, it's just the in-ground pool. And then there'll be some, patio furniture around it.
Right. Because I was looking for any grading plan, and it looks like you are going downward. You're not building up 4 walls and put some water inside.
Correct. It's an in-ground pool. So it's basically at the grade level.
Mm-hmm.
And, this being part of Forest Hill, people respect their privacy. And as you can see from the 10 consent letters, those are not only consent letters of immediate neighbors, but everyone that looks at this property or touches this property has signed off as having no objection to this application.
Okay. Okay, thank you.
You're welcome, sir.
Could I pose another question to you, Mr. Chairman?
Please do.
If we go to the site plan, which was just on the screen, unless I'm misreading it, it appears that the chain link fence and the hedge are not on the applicant's property, but they're on the road allowance. Is that correct? They look like they're outside the property limits.
Mr. Goldberg?
Thank you. Yes, through you, Mr. Chairman, that's an existing fence and an existing hedge that have been there for quite some time. And This applicant has been working with municipal standards and licensing since last March on this particular application. And they have expressed, because it's an existing, fence that's been there for quite some time, they're quite satisfied that this satisfies them from a licensing point of view and a building standards point of view. So you're correct in your observation, but it's not something that has been overlooked by anyone.
And are the requirements for screening a pool, do they require that the fence either be increased in height or that the hedge be higher, or are the existing fence and hedge satisfactory to screen a pool for safety reasons?
The existing fence has been accepted. The gating has been accepted, which is all there. And there was some additional adjustment immediately adjacent to the house, so that when you step out the kitchen door, you see there's a gate there right next to the kitchen door. There needs to be a space. There needs to be a space when you step out of the house when you're not in the pool area. So that was created, that fencing, but the rest of the fencing was existing, and it does not need to be adjusted.
So there will be no, to your initial point then, if this application is approved or not approved, there would be effectively no change to the streetscape.
That's exactly correct, sir.
Thank you.
Very good. If then there are no further questions, we can take the application into committee for a motion, or if you prefer, for discussion. Mr. Salomon.
My comments are that I think that the proposal is appropriate and that the variances are minor. There is extensive landscaping to screen the proposed pool, and it maintains the existing streetscape character, which is there today.
Very good. Do you care to make a motion?
Sure, I'll move a motion to approve the variances with no conditions.
Motion to approve, seconded by Mr. Chang.
Yes, and I just want to add to the planning staff.
Mr. Goldberg.
Sorry. Oh, it's me, Aaron. Hi. Yes, it's me. Hi. I just want to add a comment about the staff report. Like we have reviewed it. We understand the implication, but we just thought that, I mean, personally, I think that in this particular situation, we tend to agree with the applicant that the front lawn seems to be the existing entrance. So therefore, I think it is okay that even though it is considered as a backyard or a side yard, or sorry, the front yard of the building, but it's more like a side yard of the property.
Thank you. Sorry I interrupted you there. Thank you.
Oh, not at all. Just want to make sure everything is on the record.
The only, Mr. Chairman, I support what Aaron has just said. The only other comment that I would like to make is I completely agree with both my colleagues. I would hope that this isn't seen as a precedent. This doesn't mean that, at least from my perspective, that putting pools in front yards is a good idea. I think this is a unique situation.
That's very true, yes.
That's always the concern, and is there any way to address that? I mean, we are dealing here with a piece of property that is deemed to be front yard, but we can see that in fact it's side yard, and that's what's prompting our decision.
That's right.
Yeah.
Sorry, what is your issue again, just simply?
The issue of setting, this is going to sound like a precedent if approved, that the Committee of Adjustment approved a pool in the front yard.
Well, that's essentially what you're doing.
And we're wondering if there's anything we can do to, in terms
Could
of language, go ahead.
Could we add a note that just indicates that it recognizes an existing condition? The screening and the fencing recognizes an existing condition or something like that?
Well,
Would that be helpful or not?
You've got your reasons. So the first one one maintains the general intent and purpose of the official plan, maintains the general
Yeah.
intent and purpose of the zoning bylaw. Then the third would be represents desirable and appropriate development on the subject land, given its, the fact that it's a corner lot, or I can think of some wording in that regard, but just that it's
Yeah.
appropriate for this specific
Yeah, great.
parcel of property.
Yes. We'd
That's right.
like to do that, so
And then that's in the reasons.
Yeah, that's terrific.
you've captured that language, okay?
I'll craft something for you, yeah. And then you can look at
So
it when
that
we
is
do the
certainly our
minutes.
intent.
Yeah.
Thank you.
Okay, then there is a motion by Mr. Salomon. It is as yet unseconded. Now it is seconded by Mr. Chang to approve without condition. Well, to approve and the language to indicate that this is site-specific because of specific conditions in this instance. Motion to approve. All those in favor, show of hands. The motion is unanimously carried and the application approved. Okay. Committee moves on to application number 23, 16, Roxeter. We are looking at applicant materials. There is also a covering letter from Stuart Hatch, the agent. And there is written correspondence in support. 6 form letters from Roxeter, 12 Roxeter, 13 Strathcona, 619, 22 and Roxeter, and 15 Strathcona. All in support. Moderator.
Through you, Mr. Chair, we have the agent on the line, Mikio Nakashima.
Thank you. Good afternoon. Good afternoon.
Good afternoon, Chair. My name is Mikio Nakashima. I'm the agent for the owners.
Thank you very much. Just a moment while I consult with panel members. Panel, any desire here for a presentation?
No.
I don't see any. Are there any questions for Mr. Nakashima? Don't appear to be. That being the case, in the absence of questions, could we move to a motion, please? Mr. Nipfel.
Mr. Chairman, through you, I'd like to move approval of the application without condition. This is a very minor application. It's a one single variance. It's a moderate variance. And the addition that is being proposed is accommodated within dormers that are attached to the existing roof. I think it's quite compatible with both the existing dwelling and with the neighborhood. It doesn't inject any negative impact into the community.
Thank you. Motion to approve. Is there a second? Mr. Chang seconds. Motion to approve. All those in favor of the motion? The motion is carried unanimously and the application is approved. We go on to item number 24, 57 Sororan, where we are dealing simply with the applicant materials. Moderator?
Through you, Mr. Chair, we have the agent Nicholas Dell on the line.
Thank you.
Good afternoon, committee. Nicholas Dell for the record, authorized agent and planning consultant from Harper Dell & Associates. We have 2 variances before you today for 57 Sororan. I have not seen any staff comments. I've been following up with Bram and Cecilia for that, and I've seen nothing online. So if they could please let me know if it would profit the committee to proceed with the presentation, or if there are comments that I should be addressing.
Thank you. I'm going to just check with the committee to see if they appear to wish to hear a presentation. whether they benefit, no, they're saying no. Are there any questions for the applicant, committee members? Again, seeing none, could we move to a motion, please? Mr. Salomon.
Yeah, I'll move approval of the variances. There's already a second suite, and they're proposing to add a very small additional second suite. And given that that second suite is really small, I think the variances are minor, and I would move approval of the variances.
Thank you. Is there a second? There is. Mr. Nipfel seconds the motion. Motion before the panel then to approve. Show of hands, all those in favor. Unanimous vote carries the motion, and the application is approved. With that, the panel moves on to item number 25, 41 Claremont. Here, once again, we are simply dealing with the applicant's materials. Pardon me. 25 has already been deferred by the panel about 25 minutes ago. Very good. (26) 220 Northcliffe Boulevard. Only the applicant's materials are before us. And moderator.
Through you, Mr. Chair, we have the agent on the line, Jesse DiMaria.
Thank you very much.
Hello, hi, this is Jessie DeMaria.
Thanks, Jesse. I'm going to check with panel to see if they'd like to put questions to you or have a presentation. Panel members? Any questions?
I'd like to ask a question.
Go ahead, please.
I noticed that, unless I'm mistaken, there aren't an awful lot of enclosed porches in this stretch. I've found one a few doors away. Can you advise me of where there are other enclosed porches? And before you answer, I'm not saying this to be critical. The actual structure of the porch is quite characteristic of other porches in the area, and I don't actually think enclosing this porch is out of line, but I just wondered where there are other enclosed porches as a precedent.
Yes, so on North Cliff, within 2 blocks, there are 11 houses with enclosed front porches. I can also provide exact addresses. And then within our neighborhood of Dufferin to Oakwood, St. Clair to Rogers, there are 143 homes with enclosed porches that we found roughly.
Thank you, that's very helpful.
Thank you. Further questions?
Mr. Chairman, if there are no further questions, I'd like to move approval of the application without conditions. This is extremely minor. The fabric of the porch is already existing. It's compatible with the neighborhood. Enclosing the porch, I think, is something that will be hardly noticed and certainly doesn't have a negative impact on the community.
Thank you. Second to Mr. Nipfel's motion by Mr. Salomon. Very good. So, motion to approve before us. All those in favor, show of hands, and it's unanimous. Motion carried, and the application is approved. The committee moves on to item number 27, which is 202 Mavety Street. Here we have the applicant's materials, plus a report from Community Planning Toronto East York. Moderator.
Through you, Mr. Chair, we have the agent on the line, Derek Graham.
Thank you. Good afternoon.
Hello, good afternoon. Can everybody hear me okay?
Yes, we do.
Hello, Mr. Chair, and good afternoon. Yes, of course. My name is Derek Graham, and I'm the acting agent for the subject property.
Thank you very much. Okay. questions for the applicant? Presentation? No? Any questions? I have a question for you, applicant, and I wonder if you could just explain what it seems to be a big deficiency with your front soft landscaping at 33% when 75 is the bylaw. Can you tell us why you were constrained to that 33% level?
Certainly, yeah, we didn't have a lot to go on initially, and the subject is legally non-conforming or existing non-conforming. We're going to try and reduce the impact of the steps from an area standpoint as much as possible, and we'll approach the minimum allowable by code, and then the rest of it will be entirely soft landscaping. So whatever we can carve out of there, but we're not actually reducing the amount of soft landscaping. It's important to note we'll actually be increasing it as we're removing or reducing the size of the existing porch. And basically replacing that with steps. So we're cutting back the porch and we're reducing the size of the steps as much as we can to promote the largest allowable amount of soft landscaping.
Well, thank you. So the soft landscaping percentage now would be even less than 33. It's like, do you have an idea what it currently is?
I couldn't say exactly, but it's certainly less than 75%. There's very little soft landscaping allowable. So we'll actually be increasing it as best we can.
Thank you.
I do have a question on, just to clarify, from what I understand, part of the front porch is being removed and then the basement stairs are going to be excavated in that space. Is that correct?
Correct.
Okay.
And you know there's a staff report that applies some conditions.
Mr. Chairman, it's unusual for the planning department to support a direct front entrance from the basement. And I think it's a tribute to the applicant that he's managed to very efficiently provide for a planter, a down staircase, and as he indicated, an adjusted and smaller front porch to accommodate all three in the front yard in a way that the planning department is prepared to support. I think that the approach is reasonable. It's modest and it does not actually impose any kind of a negativity in the community. I'd like to move approval of the application subject to the planning department condition that ties the stair orientation, railing design, and landscape screening to the site plan drawing that we have in front of us.
Thank you very much. Second to that motion. And there is by Mr. Solomon. So motion before the committee to approve subject to the planning recommendation. All those in favor? And the motion is carried unanimously. The application is approved subject to the planning staff report. Okay. And we move along to number 2890, Croatia Street. Here we have a copy of draft plan of survey, provision of parts, applicant materials, covering letters from Maggie Bassani, February, September, and September, a previous Committee of Adjustment decision, LPAT case number is included, PL 180-288. There's a severance sketch. We have commenting reports from Engineering and Construction Services and from two from Engineering and Construction Services. And moderator.
Through you, Mr. Chair, we have the agent on the line, Laura Dean.
Good afternoon.
Good afternoon.
Please state your name.
My name is Laura Dean, and I'm a lawyer with Aird & Burles, and I'm here representing the applicant, which has been authorized by the Toronto District School Board to act as its agent for the purpose of submitting this consent application.
Very good, thank you. Okay, panel members, would you benefit from a presentation in this situation? Do you have any questions for the agent? Yes, there are questions. Please, Mr. Sauerland first, Mr. Nipfel second.
Okay, so the question I have is that in January of 2020, the LPAT gave interim approval to the draft plan of subdivision. And so what happens to that draft plan of subdivision? How does that get affected by this consent?
With a revised draft plan of subdivision. And so this consent is taking place, and that application is to be revised. And so this is part of the process of satisfying the conditions.
Mr. Nipfel?
I'm having some difficulty figuring out where the consent line is, where the two parcels are. Could you help me out using the severance sketch? Show me where the actual severance line is?
Sure, absolutely. So what's actually being proposed here is that the property would be divided into a number of parts. And so this sketch shows in diagonal lines, those lines that will be severed, and then the hatched lines, those lines that will be retained. And then the sketch provides further detail with respect to the use of the parts going forward. So you can see that there's a new public right-of-way, which is in orange, and various easements that are indicated on the plan.
Thank you, that's very helpful.
Okay.
We're just going to call up one more drawing that might give a better picture. Yeah, C2. It won't let you show it? That's weird. I can see it online. Oh, is it? It's taking a while. So if the committee members go to your document in your agenda called C2, it might give you a better, the shaded document. It just shows you the entire site. Doesn't it? Just gives you a little bit of a better picture of how it's going to be.
So what this is a conveyance of the TDSB surplus lands, which are being called the conveyed lands, or the severed lands, and then the retained lands then appear as well on the previous diagram we had been looking at.
Okay.
And there is a report from Engineering and Construction.
Yes, so I would note that the October 23rd report from Engineering and Construction Services indicated that it had no concerns with the committee granting approval of our client's application, and no comments were provided by any members of the public.
Okay, and neither of the engineering and construction reports seems to carry any conditions, does it? Panel members? Are there any conditions?
Except there, am I not correct, Mr. Chairman? There are standard consent conditions for engineering. Other than those, I don't think there are any additional, but are there not standard consent conditions that we need to apply?
If you refer to, pardon me.
That's okay, you can answer.
Oh, thank you. I was just going to note that if you scroll to the bottom of the October 23rd memorandum from ECS, you'll see the conditions that are noted there.
Yeah.
Thank you.
those will be in addition to the standard consent conditions.
Which I think are two and three would be the standard, I believe. And 4.
No, there's also payment of proof of paid taxes, and then there are other Planning Act related things that we include in our standard conditions of consent, and then these would be in addition to those.
Okay.
Okay, then, if there are no further questions of the applicant, then could look to committee for a motion, please. Motion, Mr. Nipfel.
Mr. Chairman, I don't see that this consent raises any real difficulties. I'd like to move approval of it, subject to the standard engineering conditions, as well as those conditions that are recited in the letter of October the 23rd from engineering.
Thank you. Is there a second to Mr. Nipfel's motion? There is, by Mr. Chang. So motion before the committee to approve as stated by Mr. Nipfel. All those in favor, show of hands, please. And the motion is carried unanimously. The application is approved.
Thank you all very much.
Thank you. And we move to application number 29, 2308 Queen Street East. Before the committee are draft plan of survey, applicant materials, 12 photographs. There's a covering letter from Cameron Pollicott, solicitor. There is a report from Development Engineering Construction Services. And there is written correspondence from Helen Aspiotis of 2306 Queen Street and Cynthia Bondi of 2310 Queen Street East. So, moderator.
Through you, Mr. Chair, we have 2 speakers in concern, and the solicitor, Cameron Pollicott, is on the line.
Very good, thank you. Good afternoon.
Hi, can you hear me?
We do hear you.
My name is Cameron Pollicott, and good afternoon, Mr. Chair and the members of the committee. I'm an agent for the property owner.
You have 5 minutes to present your application. Please, please continue.
On behalf of our client, we're the ACLP QSE, we're the april of the property. We're submitting consent to application to sever the property into 2 separate lots. The property was merged in April 20, 2016. It is, and if I could point you to the draft R plan that was presented, the application to sever would sever parts 1, 2, and 3 on the draft application. And there would be retained lands within that of parts 4, 5, and 6 in the rear. And that rear part of the retained lands are subject to easement rights for our adjoining neighbors. There is no, we're not proposing any changes to the building or structures as constructed on the adjacent properties. There are no changes to this. Owner intends to retain the back portion of the property as indicated in part 4, 5, and 6. There's a daycare on that lot and on that line. The building and use of the adjacent properties and the use of the retained lands as a playground area were approved by 2 building permits from the city. No changes again are proposed to the building of the adjacent properties, nor is any change proposed for the use of the adjacent properties on the retained land. And there are, again, no proposed changes to the use of the conveyed land as a mixed-use property with a retail residential building on it. I can address the areas of concern, and our clients reached out briefly to Mrs. Bondi, Miss Bondi, and Mrs. Aspiotis. With respect to the encroachment raised from Ms. Aspiotis, we reviewed the photos. I don't believe there to be an encroachment. And the site plan was submitted to the City of Toronto and approved by the City of Toronto for the development of the playground on the adjacent properties. So I don't believe that the fence line encroaches. And I don't, and again, I would underscore that the intention of this will not affect Mrs. Aspiotis nor Mrs. Bondi's use of the right of way. They have rights on title to their ingress and egress. Again, our client is in asking for the severance of the property. It's not intending to change the use or the enjoyment of the existing laneways or to obstruct their legal rights. And an approval here would mean effectively no change to their rights as it pertains to their legal rights there. We have submitted our preliminary project request to the conveyed land. There are no minor variances for either the conveyed land or the retained lands. And that would be my proposal and my presentation.
Thank you very much. Okay, panel members, shall we proceed to the speakers in opposition? And okay, we'll hear from the first one, moderator.
The next speaker is Cynthia Bondi, sorry.
Good afternoon.
Good afternoon. I'm Cynthia Bondi at 2310 Queen, the owner.
Very good. You have 5 minutes to address the committee. Please carry on.
Okay, I think it's hard to understand without a site inspection, but the right-of-way that we use is very narrow, and the daycare part 6, the playground is, everything's fine the way it is, but if they sell 2308, and new owners that have approached me have told that they're going to build deep and up, it's going to affect the parking if 2308 doesn't get a parking spot. So there was 5 garages on part 6, and they got rid of those for the playground. But it was all the same owner, 2308 and 2316. So we're to pull into that laneway, you cannot back out. You have to do a 3-point turn. So if it changes, we don't know how we'll get back out. And it's very unsafe to actually back out onto Queen Street with the little daycare kids and dogs and that. So it's hard to explain without a site inspection, I think. That's it. Thank you.
Thank you very much. Questions, panel members, for Cynthia? Yes, Mr. Nipfel.
Ms. Bondi, I'm looking at the plan right now. Is the parking that's behind your building, is that your parking space?
My parking space goes under my deck. It's a carport that I've used for 25 years. So I do pass over part 3, I guess. But they started that before I owned because the laneway actually went all the way out to Kingswood. But fences went up and that ended that. So before I was an owner 25 years ago.
I wonder, could we get the drawing, the one that was just up, the one that shows the 3 cars, and it indicates the various parcels of land. I'm trying to figure out how you get to your parking space, Ms. Bondi.
I know,
Because there's a car parked there behind you. So whose parking is that?
I can't see what you're looking at right now.
Okay, if they can put a drawing, can you see the screen, what we've got here?
I can see all the panel people, but no pictures anymore.
Sorry, Carl, you just need us a few minutes to get it up on the screen. Yeah.
Okay, so it's coming, and then maybe this will all be clearer for you.
Okay, that's, yeah.
No, not that. No, just hold on a second. There.
Yeah, we know which one. We know which one. We're just having trouble getting to it.
There we go, that's it. Okay,
Oh, I lost it. Okay.
okay,
Okay,
I
there,
see
that's
your,
good.
okay, you've got an existing deck and you park underneath that, right?
Yes,
But there's a car there that would appear to block, unless you can really
that's
drive
right.
well.
Therefore, I
Whose,
couldn't.
whose parking is that? The car that's behind your deck?
No car, well, that's not my car, but that's where I'd have to park, and that would be the right of way. Because normally I park, I turn and pull right under my deck. They have two cars there. Two cars have never parked like that behind 2308. And that would, if that second car was there at 2308 parked, no one could back up and actually get forward to go out safely.
So just to be clear, 2310, okay. All right, there's 2310. Oh, right, sorry, it's all right, I answered my own.
Yeah, if there was a color to the cars, I could tell you which one. But the rear car, the two cars parked together. Now, the one more technically north, that would block, I normally pull right in under my deck there. Before, I gave the, I signed off for the daycare to go deeper because that was more right away. I guess I could have pulled forward and backed in under my deck, but I didn't know this was all going to happen. So now I could pull it, and I could never get under my deck if two cars are there, is what I'm saying. And then I'd
Okay,
have to park in the laneway, and then I could never get out without backing all the way out.
but you couldn't park in the laneway either if that third car was there, right?
Right. So I don't know what third card that's supposed to be, but I didn't
Okay,
see this
maybe
drawing.
the applicant can clarify, because I share your concern about being able to move around in there. I don't know how it would work either, but I don't know whose car that third car is.
Yeah, I didn't provide that drawing, so I'm not
No, I
sure.
know.
Okay.
I'm just asking you how it works. Thank you.
Yeah.
So what we'll do then is when we get back to the applicant for rebuttal, we can ask them to explain the rationale behind this particular drawing of their proposed parking plan. Anything further, Ms. Bondi?
The other neighbor will explain more. Thank you.
Thank you very much. Moderator.
Next speaker is Helen.
Good
Yeah,
afternoon.
say hi. Hi, my name is Helena Spiotis. I never see those parks, these cars there before. In this drawing. And on this drawing, you know, I never see. I give the authority to my daughter to explain to you.
Helen, excuse
yes.
me for just a moment, please.
Yes.
Helen?
Yes.
I'm going to ask you to speak up or to get a little closer to your microphone.
Okay, okay.
Just so you're a bit clearer. And
Yes.
this drawing here, we understand that that drawing was submitted by the applicant. So when the applicant's turn comes to rebut, we're going to ask the applicant to explain this drawing very carefully to us.
Yeah.
But you now have 5 minutes to address the committee. Please, go ahead.
Okay, so we agree with everything that Cynthia just said, that the mutual lane there is very narrow, as you can see by some of the pictures that we have provided, especially the one. So if 2306, 2308 were sold off and there was parking, if it was sold with parking, then 2306 we wouldn't be able to make a 3-point turn to take our cars out of the laneway. Like, it's very narrow back there. So the concern is any amendments that 2306 wants to make to that, to the existing right of way. And there's no way that, I know that we're talking about that drawing with the two cars. There's no way that cars can be parked that way there.
Absolutely not.
Okay. Do you mean those cars, the cars we see parked there, they couldn't make their
No,
3-point turn to get out?
No, no,
Absolutely.
absolutely not. Yeah, they can't even park that way. There wouldn't be enough room to be parked that way. So I don't know, this is imaginary. So, yeah, our concern is the amendment to the easement, the right of way. There's no way that, I mean, if anything gets changed, everything has to stay the way it is. Otherwise, our tenant, who is at 2306 right now, who is a restaurant, would not be able to park back there if, so, and would not be able to make a 3-point turn to get out.
Thank you. Helen, can you tell us, I know it's hard when you don't have a finger to point on the drawing, but where do you park your car now? Is it shown on this drawing where you park your car?
It's not on this drawing, but it's right behind where our property is. So you go through the laneway and then you make a left.
A left turn, okay.
Yeah.
Further west.
Yeah, further west, we own 3 garages that are back there. So we park in front of those garages.
And what you're saying is that you, to get to your parking, you come up and then you back into your place, do you?
No, we can go in and make a left.
You make a left going forward.
Make a left, but then, yeah, go forward, but then we need to get out. You need to back up and kind of turn, right? Make a 3-point turn.
Make a 3-point to get out.
Yes, because it's very narrow.
You have to do a 3-point to get out, so you would be backing up presumably to where the one car is parked right now by itself.
Yes, exactly.
I'm beginning to understand this much better now. Thank you.
Through you, Mr. Chair, I just have have we talked to all the concerned?
Yes.
I have a question for the applicant. Just regarding the retained parcel of land, is that to be added to additional holdings, or is it going to be a landlocked?
They're using this area.
Okay. We're going to be going back to the applicant's muted right now, right? Yeah, that's right.
Through you, Mr. Chair, the applicant is unmuted. We're trying to respond to the Deputy Secretary Treasurer's question. Very good. Go ahead.
Hi, thank you very much. And it's Cameron again. We appreciate that it's a narrow entrance point. It's really just a drawing with those cars in there. That third car, Mr. Speaker, that I think you were referring to is, I mean, I think maybe it was put there because our client looked at this as though that was the neighbors using that. In essence, that's not a right that we're looking to park or use that area. I think the issue is the 2 cars that exist. The thing that I think that is important is to look at the location of the easement. The easement, if you can see just to where, if you look at where the 2 cars are, and it's hard when I can't manipulate that, but you can see the easement rights for Miss, and I apologize for the name, for Miss Espioso, for our property to the east. It extends over only over that proposed area, that kind of marked line there. That's so her easement right for ingress and egress shouldn't extend over that line to where those cars are parked. If you would look at the image where the 2 cars are lined up, whether or not she can do a 3-point turn or not, those cars, that area isn't part of her easement rights or the easement rights that are enjoyed by that property owner. Our intention is not to change this, and this drawing was done for, purposes of illustrating how this site could be used. Whether or not cars will be parked there, I'm not sure. But that area is entirely our area, and it's not the easement area that is in question. It's not neither party has rights to that area. I don't think we encroach over the easement area with respect to the metal fence that exists. But I can, illustrate that particular spot where those cars are shown is not an easement, is not an area over which the passage of cars for our neighbors should be utilized. But again, our intention isn't to obstruct it or create a fence. Quite frankly, it just seems that the cars were put in there for the purposes of illustrating how that site could be utilized by our client and putting a compact car in there. But for our Mrs. Bondy site, we are entirely open to allowing her ingress and egress and supporting her rights, and that goes for the neighbors as well. But I don't want to suggest that we're going to forego our rights because by virtue of using our property or utilizing our property, the owners of our next door neighbors are entitled to the rights as they have been codified, not as they see fit.
Thank you. Yeah, we understand that now. I just want to check with the Deputy Secretary Treasurer whether she has an answer to her question about retained parcel of land.
Yeah, no, I'm just going through some of this. So the retained parcel of land, is that to be added to adjacent properties? The covering letter just talks about adjacent properties, but they're not shown on your plans. Or is it going to be a landlocked parcel of land, separate to itself, under separate title? I'm just concerned that perhaps that should be a lot addition application. I'm not sure.
So parts, the parts, we have a merged piece with 7, 8, 9, which are 2, 3, 16 and 2, 3, 12. The retained lands as they are referenced in this property would be over parts 4, 5, and 6. So our client would have in essence merged 4, 5, 6, 7, 8, and 9.
But you haven't mentioned 7, 8, and 9 as part of the application.
Yeah.
Are they registered under the same?
Yeah.
We have, yeah, we've referenced in the application.
They're not referenced in the members' information here. You're conveying parts 1, 2, and 3, and then it describes retained parts 4, 5, and 6 that will not have a lot frontage in a total area of. There's no mention of it being merged in the notice of public hearing that was issued with any other parcels of land, or that it is currently part of, but I'm not sure why the other parts were not mentioned under the retained parts.
Well, our position is that they will have merged under the
So the correct description in the notice of public hearing that was issued, and for the committee members, for the minutes for a decision, it should be that the retained parcel of land is parts 4, 5, 6, 7, and 8?
and 9.
And 9.
The properties were purchased as two separate transactions. There's three separate parcels in April 2016. And the way the property has functioned since that, well, from the beginning is...
I'm concerned more about how is it registered. Currently, it's under one ownership.
It's under one ownership, yeah.
The whole thing.
And there are 3 separate parcel
This particular application, you are only conveying the one parcel, which is 1, 2, and 3, with an easement over parts 2 and 3.
Correct.
And then the retained parcel is parts 4, 5, 6, 7, 8, and 9.
That's correct.
Okay, we'll have to amend that for the purpose of the decision, because it doesn't read that way. Okay, thank you.
Okay. All right, then I guess we're at the point now at which panel members could address questions to the applicant with respect to the application. Mr. Sallin.
So my question is, part 3, which indicates that it includes the easement, is like that part 3 is that little triangle piece. How do you superimpose that on the site plan to show what effect, where part 3 is located in relation to those 2 parked cars on the site plan?
We believe part 3 would be for our use and enjoyment of the easement, so it wouldn't be landlocked. And Cynthia Bondi, but the rights of the adjacent owners are subject to easement rights as they are drafted and registered on their title. Under 2308, the instrument that's registered there is CT 3830848, and we're bringing that forward onto our title.
But part 3, that easement gives the adjacent landowners the right to drive over that land. Am I correct?
It only gives 2. It gives us and it gives
in order to access their parking.
It gives us rights and Cynthia Bondi rights.
Okay, so if I'm looking then at the site plan, which shows 2 cars parked at the north part of that new lot, are those, is that one of those cars parked, is it sitting on it, on that part 3 where the landowner
Victoria,
needs
it's sitting on that side, so
access.
the cars, this doesn't work.
If we could get a split screen, it would help, because Mr. Solomon's point is a good one. Looking at the 2 drawings separately, it looks as though there's a triangular piece of land that affects the parking of that most northerly car. And Miss Bondi would have access or easement rights over part 3, which means that I'm assuming you can't block her access to parking that's underneath the deck. That's what I heard.
Hi, Carl. Jacob here. Unfortunately, we can't do a split screen while screen sharing.
Okay, thanks anyway. I've got it on 2 different screens, so I mean, I'm with Solomon on this one. I think there's a problem.
Yeah, so when you look at the dimension on part 3, I think it shows 3.11 meters from the right corner to the beginning of that curve. And so if you measure on the site plan 3.11 meters, is that then starting on part of the parking spot that you're showing on the site plan?
It's hard. Can you hear me?
Yes.
I can't confirm. I can't confirm looking at this, and I know what you're saying with that triangular piece that's there, and I agree, but I can't confirm without an overlay. I think I'd have to have our surveyor confirm in that respect and overlay that. I think perhaps the site plan that's there is maybe misleading, and so we'd have to review that with our surveyor.
Well, we can't do that this afternoon. But that part 3 does appear to be sort of the crux of the issue here with respect to, as I see it, with respect to 3-point turns and being able to get in and out of the lane.
I think what needs to be done is perhaps for a deferral so that the applicant can revise the site plan to show where part 3 appears on the site plan, and to redo the parking to correctly show how the parking will be working on that site, and how many parking spaces are required and will be provided.
Yes, so that makes, shall we take this,
Can I also make a suggestion, if you're going to be deferring this, that when this comes back, that perhaps maybe a color-coded draft plan indicating what's going where, maybe that the part 3 needs to be an easement as well, I don't know, but maybe after speaking with the neighbors, they can sort all of that out. But perhaps just from the exercise of having to work through this virtually, that if the applicants can kind of, if they take anything away from this, to maybe prepare some documents that could be a little bit easier to follow along with.
I'd like to see committee take this into committee now for discussion of what our options are with respect to how to proceed this afternoon. So we are now in committee, and Mr. Solomon's point makes sense to me that a deferral would would help us get some clarity on this, because a lot of the fact that we're not clear is because of the nature of the drawings don't reflect. We're having difficulty trying to interpret the drawings to see what they really mean in terms of a very tight parking situation and entry and exit situation.
Mr. Chairman, I don't think we have sufficient detailed information to judge this application correctly. I would support, if Mr. Solomon brings forward a motion of deferral, I would support that for the reasons he mentioned. I'd also suggest that the point that the Deputy Secretary Treasurer made be added to the motion. And the third thing, I think, is that the other reason for deferral is so that the applicant can negotiate with the owners of 2310 and 2360 about access to their properties. Those are the issues that we can't solve today.
Yes. I agree with you. So it's consultation with the neighbors, a color-coded plan.
So I would move a motion of deferral on that basis.
Go ahead, Mr. Solomon. Oh.
Yeah. So I would move a motion of deferral, and that gives the applicant to make those modifications to more clearly show the information we're looking for, and to consult with the neighbors, and also to provide a color-coded kind of plan that shows this information.
And Madam Deputy Secretary Treasurer, should deferral fees apply or not? Do you care to add that, Mr. Solomon, that deferral fees to apply?
Yes, I'll add that as well.
Thank you. So, motion by Mr. Solomon to defer as stated, seconded by Mr. Nipfel. Motion before the committee. All those in favor, show of hands, please. Motion is carried, and the application is deferred for the reasons stated. Thank you. Committee moves along to application number 30. (2165) Gerard Street East. And on this application we have before us copy, draft plan of survey, applicant materials, covering letters, Sean Galbraith, agent. We have staff reports from Engineering and Construction Services and Urban Forestry. There is one letter in support, in writing, correspondence from 12 Swanwick, and there is opposition correspondence in writing from 14 writers. Moderator.
Through you, Mr. Chair, we have the agent Sean Galbraith on the line. Further, there was a speaker in support, Craig Race, who was in the hearing after I called him, but he has since left. And there's one speaker in opposition, Mark Postil.
Thank you very much. Good afternoon.
Good afternoon.
Could you state your name, please?
My name is Sean Galbraith. I'm a planner here on behalf of the application.
On behalf, okay. How about Ralph Polahemo?
He's the owner. I'm speaking on his behalf and on the project's behalf.
Very good. You have 5 minutes to address the committee. Please proceed.
Thank you. The application before the committee, I think, is very straightforward. It is simply a consent application to split the existing large lot in half. The resulting 2 lots both fully comply with the lot requirements of the zoning bylaw and conform to the official plan. They are entirely in keeping with the lots that exist in the area and do not set a new precedent or standard. There are no engineering concerns with the project, and we are in agreement with engineering's requested conditions. Urban Forestry has indicated in their letter that they do not object to the proposal, and we are okay with their conditions as well. Planning staff has no objection or comment on the proposed consent. We understand that neighbors have expressed concerns with what the owners want to build on the 2 lots. The owners intend to develop the property with semi-detached 4plexes, each with laneway suites in the back. And these are entirely in keeping with the permissions of the zoning bylaw. This proposed development would require 0 minor variances and provide much needed new family-sized rental housing units, which the city very much needs and wants to encourage. I note that this potential development is not before the committee today because, as I said, it doesn't require any variances. Only the consent is before the committee. An application for 2 singles would require the same application. And I would also like to note that we held 2 public information meetings for neighbors to discuss the original proposal, which was for 3 townhouses, and the revised current proposal. I'd be happy to take any questions you have.
Thank you very much. Panel members?
So my question is, we do have a memo from Urban Forestry dated November 18th, which says although they don't object to the approval, they set out conditions and they have an issue with the large tree at the back that's proposed to be removed. And I'm wondering how do you respond back to their concerns?
Muted? Oh, there we go. Hi there. So the large tree in the back is not proposed to be removed. We are retaining that tree. The comment from Urban Forestry is essentially that we shouldn't assume that just because we get the consent that we will be given a tree permit. We understand that, and we agree that we still have to submit a tree permit. There currently is an active tree injury permit for that tree because we removed a garage. And at one point in the early design stage of the project, there was a proposal to build a garage back there instead of a laneway suite. And so an injury permit was obtained for that. We fully intend to retain that tree, and the foundation of the nearest laneway suite has been designed to work around the roots of the trees by using helical piles and not a traditional foundation. This project is being done to full passive house standards and will not include any concrete in the foundations. It will all be more traditional methods. And so with no foundation, there can be minimal, if any, impact to the root system of the large tree. And if we were proposing a garage back there instead of a laneway suite, that actually would require the removal of the tree to accommodate the driveway. Our proposal saves the tree, frankly.
Thank you.
You're welcome.
Okay, if there are no further questions, we can move on to the person speaking in opposition. Moderator?
One quick question, Chairman.
Go ahead, Mr. Chang.
Yeah, so you said that you are not going to have any foundation, but you have a basement.
Yes, so there is a basement in the main house, but it is not using concrete for the foundation.
So sorry, I just unmuted. So I see it now. So the secondary suite at the back near the tree will have no basement.
Correct.
You'll be using helical piles to support it. Okay, fair enough.
Exactly.
Got it. Thank you.
You're welcome.
I have one question as well, Mr. Chairman.
Please.
On the survey, you indicated that you are in compliance with the lot pattern in the area. On the survey, the drawing or the survey indicates 2163, which is the property immediately to the west. That's a semi-detached dwelling, I believe. What is the size of that frontage? Because it appears, at least from the survey, to be about a third the size of your frontage that you're talking about. Is that correct?
So there are three lots west of us. Those three lots combined roughly equal the size of our existing intact lot.
Yeah.
So
okay. So those lots are about a third the size of yours.
The graphic that's on the screen now is very illustrative. Yes, that is correct.
Okay.
And in the most recent cover letter that I submitted, I've highlighted the lots in the area that are similar in size or smaller than the proposed.
Thank you very much.
You're welcome.
Okay. Let's go now to the person in opposition.
And next speaker is Mark Postel.
Thank you.
Hello, can you hear me?
Yes.
Okay. My name's Mark Postel. My wife and I live at 2163 Gerard Street East. That's the property to the west. It's a single detached. We have a single detached, and then to the west of us, there's a semi-detached.
Okay.
You have 5 minutes to address the committee.
Yeah.
Tell us the impact.
They are going to take a single-family home where 4 or 5 people have lived and a basement rental, and they're going to replace it with 10 two-bedroom apartments. And they've always insisted that this is going to address Toronto's missing middle, but I don't think it's going to address Toronto's missing middle. There are lots of other things they could do with that lot that would provide for families. I don't really feel like this is going to provide for families. I keep seeing the plans, but I'm a bit confused by the plans, but I think those were the original plans that you're showing. I think that the original plans showed an entrance at the front of the fourplex, but then there are new plans filed after that showed the entrance at the side of the house. So that would be between my house and the fourplex, and then it would be on the other side. They are going to eliminate the parking on the lot, and because they say that the parking requirements are eliminated when they're a laneway suite, you're going to put 10 units on the existing lot and not provide any parking at all when the streets around us are already full of parking. That's a major concern for all of the residents. If you look at the letters, that's one of the concerns. The safety of the laneway suites is a concern. My wife and I park in the back. I'll be backing out of my parking spot right in front of the one of the laneway suites. Mr. Galbraith talked about the tree. That's a major concern for us. The original permit for a garage had to be amended so that I believe that they moved it to the west side of the lot, or at least the exit had to be moved to the west side of the lot so it wouldn't impact the tree. The original structure that was there was more like a carriage house. It opened into the backyard, and it was never used as parking for a garage. It never exited. But I understand that the tree will be dealt with by urban forestry. Our main concern is that the lot size may be appropriate, but the density for the lot isn't in keeping with the neighborhood at all. And then my specific problem is that between the fourplex, if I understand the plans correctly, the more recent plans, the entrances to the fourplex are on the side, not in the front. Now, on the other side of my house, I have a like a walkway between the houses, and it's about 122 centimeters. And I have to be careful taking the recycling bin out so that I don't bang into the walls between the houses. They're proposing that a structure that's going to house four tenants at least, is going to exit onto that 120 centimeter walkway between the houses. And I'm concerned that, well, first of all, I'm concerned that if they try to bring in mattresses or furniture, they're going to be out of luck or else banging into the house. And I don't know how to protect my property from people using that as the laneway. I realize it's small, but I don't understand the legality of easements. So that's my specific concern, that the entrance to that fourplex is going to be like right underneath our bedroom. And like 150. Yeah, I'm fine, that's good.
You need to make your wrap up now, please.
Yeah, in our neighborhood, houses have doors, homes have front doors. Homes have front doors because it's welcoming. They're proposing a fourplexes with doors on the side that say we're squeezing this in the best way we can. That's all.
Thank you very much. See if there are any questions for you from the panel members. Panel members, any questions for this speaker? I have one, and that was, you mentioned, Mr. Postel, that while the building, the existing building is a single-family dwelling, but you're saying that there are, is it subdivided into 5 separate units now? Or you said there were 5 people living there. Is it subdivided inside, or do you know? Or is it a family of 5?
Yeah, there is. So we've been here for 12 years, and there has always been a family of like 4 or 5 living in the house. It's a house with children, and there has always been a rental unit in the basement, which has always been a single person or a couple. But it is a single family home, and there aren't many of those left.
Okay, thank you. That helps me. Any other questions for him? No. Okay, then we shall return to the applicant. And
thank you.
So I know that, you know, as you mentioned, your proposal doesn't involve any minor variances on the 2 actual structures you intend to build. But
correct. We already have zoning. Sorry to interrupt.
There is concern about the density that you're doing. You may want to address that, but if we could have your response to what Mr. Postel has to say, please.
So my response is that his concerns are with items that are not before the committee today. As I mentioned, the only thing before the committee is the consent, and the rest is entirely as permitted by the zoning bylaws. So if there are concerns with what we're proposing, I would suggest that the concerns are with the zoning bylaw. We're allowed to build what we're proposing with the approval of the consent. with regards to the tenants, so there was there's one family in the building now. There was there used to be a basement apartment which had a family of 4. They bought a house in Aurelia and have moved out. Our building our proposed units are all family size. They're all 2 bedrooms, with the exception of the laneway suites, which are 3 bedrooms each. We think this will be entirely appropriate for families if they so choose to move in. With regards to parking, again, the laneway suites bylaw, its great innovation was that a building or a lot with a laneway suite on it does not require any parking. And in some areas that might be a bit more challenging, but in this one, we're on Gerrard, we're within a short walk to Main and Danforth, the GO station, subway, and a streetcar line. We think this is a great location for a no parking project. And there are parking, street parking passes available according to the city. With regards to the safety of the laneway suite, I'm not really sure how to respond to that. We think having eyes on the lane increases safety versus its current condition. And I don't think it will be too difficult for Mr. Postal to maneuver his car. I'm not sure what other comments you would like me to address. I think I got them.
As I read some of the letters of opposition, as you're aware, there were a number of them. The issues were brought up, a lot of them related to safety in the laneway. As the writers thought about, many people, many cars. So
there was a comment that that the laneway suites will make the lanes unsafe due to traffic, and there was a mention of in one of the comments that there was a recent shooting in the lane or something to that effect. Again, the comment is almost a moot question. We're allowed to put a laneway suite on this property, right now. Without any variances. We're allowed to put a 4-plex on this building, on this lot right now, without any variances. Eyes on a lane make lanes safer. This is a long-established practice that eyes on a street make a street safer. So I don't think that the lane will be made less safe because we're not putting more cars on it.
Thank you. Okay.
You're welcome.
Mr. Salomon, the question.
Yeah. I'm looking at the architectural drawing, and the question I have is, it shows that the entrance to the main building for those units is from the front of this along the street. Is that correct?
That is correct. And so the side yard setbacks are wide enough to accommodate the required access to be from the front of the property versus through the lane.
And so is the entrance to the units in the main building, are they on the side of the building? Because that was a question that the abutting landowner had, and the drawing shows that in fact they're from the front.
The drawing shows that they're from the front.
The architectural drawing shows that there's a front door for the main building on the street.
Can you scroll down if I may, Mr. Patel, to the
there it is there.
The first floor? Okay, see, I see that. Yes, thank you. So that the neighbor was correct that that was an earlier iteration. It's been worked on subsequent. The current version of it has the entrances on the side with the walkway connecting to the front. But again, no variances are triggered by that. And that the question of where the entrances are located is not, it's not a question that's before the committee today. Only the consent is.
But through you, Mr. Chair, the members need to consider the purpose for which you are, regardless of whether or not there are variances, the purpose of which, yeah.
Yes,
and the suitability of it.
Absolutely. We have to consider the desirability of the application.
Just want to remind the members that the tests for consent are different from minor variance.
Right.
That is correct. There are 13 tests for consent applications. They're more technical in nature. One of them is does it meet the intent of the official plan? And in my opinion, this does.
Panel members.
Especially.
Sorry. Panel members. Further questions, if there are any, for the applicant?
Mr. Chairman, I have really difficult problem with this application. There's much about the architectural solution that I find wanting. And as the one of the people in opposition stated, he was concerned that yet another grand house is being lost. And I think that that's a valid concern. I know this area well. It is a beautiful house. The one that's being taken down is a beautiful house. What it's being replaced with is, in my view, unfortunate. But we're not here looking at variances to the bylaw, as the applicant has said. We're here looking at whether or not these consents make sense. The lot pattern that's proposed, as has been indicated, is in keeping with the lot pattern in the area. But to the point that the Deputy Secretary Treasurer raised, I'm not convinced that this severance is going to lead to an appropriate purpose for the lands. I think that what is proposed is too dense, technically difficult to accommodate, and as many of those in opposition have stated, there are serious problems with how this will actually function, both in relationship to the immediate neighbors, in relationship to the community, in relationship to the street. So notwithstanding the fact it is a consent without variances, I really have serious concerns about where this consent may lead us.
Thank you. Anyone else wishing to comment?
Yeah, I would concur with those comments, and I think it's reflective of the comments we've heard from the neighbors in the area.
Yeah, I agree as well, and I thank you, Cal, for articulating all these comments and ideas nicely, and I completely agree with you.
Yes, and for my own part, I mean, I look at those letters of opposition, and that's, you know, there's a lot of sense behind those, and that they all seem to be coming from about the same place in terms of their concern. So, okay, there we are. Then I would look to committee for a motion.
Mr. Chairman, I'm going to move that the application for consent be rejected. My reason is that I don't believe that dividing the property as proposed is in the best interest of the community, and I don't think that it creates a situation which, when developed, is appropriate. I think that the purpose for the consent is, in this particular case, questionable in terms of the public good, and therefore that's the basis for my motion of not approval.
Thank you. Motion to refuse the application by Mr. Nipfel. Is there a second for that motion? Mr. Salomon. Okay, motion before the committee. Seconded, Mr. Salomon. To refuse the application, all those in favor of the motion, show of hands, please. It's unanimous, showing the motion is carried, the application is refused. And the committee moves along. To number 31, 1220 Dundas Street East. Here we are looking at copy draft plan of survey, parts listing, covering letters from Zach Bradley, previous consent and minor variance applications from the committee, presentation material from Zach Bradley, the agent. We have email correspondence from Right-of-Way Control Centerville, Canada. And we have a staff report from Engineering and Construction Services. There is correspondence in support from Sherry Johnson, the Executive Director of Crow's Theatre on Carlisle. And Mr. Moderator?
Through you, Mr. Chair, we have no speakers in opposition, and we have the agent Zach Bradley on the line.
Thank you very much. Good afternoon.
Good afternoon. My address is 1230 Dundas Street East. It's Zach Bradley here.
Thanks very much. Okay. Panel members, we have the applicant with us. Do panel members think they would benefit from a presentation? Would they have questions to put directly to the applicant?
I've got a question.
Go ahead, please.
Yeah, my question is the existing 12-story condo, are they the applicant or what's their connection? Are they, if they aren't the applicant, is there a letter of support from them?
That question was directed to the applicant, I believe, correct? Yes, it was. Would you mind repeating, Mr. Salomon?
Oh, I heard the question.
Okay.
No, the condo corp is not the applicant of this. We are the applicant. We are the owner of the commercial property below grade. The commercial building, it's a retail commercial space. It has no connection to the condo corp, and they're not involved.
So is the condo, like I didn't quite understand. Maybe you can just go over the plan and so I can understand where that condo is then.
Yeah, of course. I provided a presentation if you want me to run through it quickly, or I could just explain that.
Maybe we benefit from that, and if you could highlight the relationship between the different parties, please.
Okay. I'll just wait till it loads.
Which document do you want us to post for you?
Just the presentation, I guess, that I provided.
Okay. E4?
So I can run through this quickly, then we can pull up the draft plan.
Carry on. You'll have 5 minutes.
Okay, yeah. So I'll just skip forward to our second slide, or third slide. Keep going, please. Here. So you can see this is the existing ground floor. The portion that we're dealing with is the commercial space. So if you go to the next slide. You can see here, it's just a small severing of commercial lots. Both lots are already being rented separately. The person who's severing into purchase already is renting the space, which is Crow's Theater. It's a nonprofit arts space. You can go to the next one, please. This is an explanation. This is the space on the outside. You can see the condo building is above it, but this is on the ground floor, commercial space. It's going to become a multifunctional rehearsal and performance and event space for a nonprofit arts theater in the East End of Toronto. Crow's Theater is actually on the line too, if we wish to speak to the owner about the use of the space. Next slide, please. This is the ground floor of the reference plan. So what we're proposing here is a severing. You're seeing part 1 and part 3, as shown in pink, will be severed and conveyed to Crow's Theater. Part 4 and the remaining parts in yellow will be retained by our company, Shepco Properties, which owns them. Part 4 will be created as an easement that gives access to the elevator, to an electrical room, and to an exit. Next slide, please. And just to get a better understanding of the space itself, you can see that's a floor plan there. So you can see in pink, that's the space they have. You can see there's an entrance off of Dundas and an exit into the back. And then there's also the easement there shown, which has access to the elevator, an electrical room, and an exit. Next slide. So that's all for the end. We submitted a detailed reference plan that shows all floors, but again, this is just on the ground floor. We are the applicant and we are the owners of all the commercial spaces on the ground floor, so there's no connection to the condo. The only connection is we have a cost sharing agreement with the condo and to which they are a party, and we have been entering that, and we've entered that through our lawyer, and all has gone well for that. So there's no role for the condo, and they're not an applicant, and they're not, none of their properties are being impacted.
Thank you very much.
Thank you.
And committee members, would we profit from hearing briefly from Sherry Crow for Crow's Theater? No? We don't have Sherry Crow. Okay. Thank you. Apparently Sherry Crow is not available to us right now, so okay. Mr. Chang, I'm just going to comment to you that the sun has come around and it's now reflecting off your computer screen to, there you go. All right. Panel members, any further questions? Now we've heard the presentation from the applicant. Any further questions of the applicant? Or are we ready for a motion?
Yeah, I'll put forward a motion to approve the consent, subject to conditions, standard conditions from engineering construction services.
To approve subject to the standard conditions, engineering?
No, they're standard consent conditions.
Thanks.
Always engineering.
Very good, okay. Motion to approve.
And there are some, I believe there's an engineering. Yeah, just asking about municipal numbering.
Yes, there's an engineering report dated November 25. Would you like to include that, Mr. Salomon?
Yes.
This relates to municipal numbering.
Yes.
Very good. So motion to approve from Mr. Salomon. Is there a second to his motion? It is seconded by Mr. Nipfel. Motion to approve before the panel. All those in favor, show of hands. And the motion is carried unanimously. The application is approved as stated. And panel moves on to number 33. We've already deferred number 32. So we go to number 33, 382, Dover Court Road. This is the last application on today's afternoon agenda. And we are dealing here with a copy of minutes from the January 29, 2020 public hearing, copy draft plan survey, various applicant materials, covering letter Andrew Dale's agent. There is a stormwater drainage assessment prepared by FP&P. And there is a staff report from Community Planning, Toronto East York, and another from Urban Forestry. Correspondence in support was received from Jean Chen of 382 Dovercourt Road. Moderator.
Through you, Mr. Chair, we have Andrew Dale as the agent on the line, and there's one speaker in opposition, Siobhan Lee.
Oh, there is one speaker, okay.
Siobhan is located at 382 Dovercourt. She's a tenant.
Very good. In that case, good afternoon, Mr. Dales.
Good afternoon, Chair and members of the committee.
You're Andrew Dales?
I am. I'm Andrew Dales. I'm a planning consultant for AIPL, the owner of 382 Dovercourt Road.
Thank you. You have 5 minutes to present your application to the committee.
Great. Okay, so prior to the first hearing on this matter last January, there was planning staff support for the proposal after we worked through the details with them over many months, but the neighbors at 5 and 7 Hayden Park Road expressed a concern about the possibility of basement flooding, which they feared would become a problem if the development was approved as it was proposed at the time. So after a deferral was granted by the committee on January 29, 2020, we did a lot of work with the neighbor at 5 Hayden Park Road and her advisor to satisfy the concerns regarding stormwater management. We retained, as you've noted, a civil engineer from Fabian Papa and Partners, Mr. Robert Filippuzzi, to propose stormwater mitigation measures. And he recommended that the south walls of the basements of the proposed semis should be shifted to the north to increase the permeable area of the rear yard. The civil engineer also proposed a swale between the proposed house on Site B and the house at 5 Hayden Park Road. And that swale will facilitate stormwater drainage and also function as a walkway for wheeling garbage bins to the curb. The civil engineer concluded his opinion is that the permeable area in the rear yard will allow stormwater to infiltrate and the swale will be large enough to convey the 100-year storm flow through the site to Hayden Park. The owner also agreed with the neighbor on 5 other items that are listed in my letter that accompanied the resubmission. The items include privacy fencing, the waterproofing of her east foundation wall, and a requirement to provide a final grading certificate in accordance with the drawings that were prepared by the civil engineer. We also agreed with the owner of 5 Hayden Park to request that the committee impose a condition that the buildings must be built substantially in accordance with the architectural drawings as well as the storm drainage plan. And as you've noted, the neighbor at 5 Hayden Park is now fully on board, and she submitted a letter supporting the proposed consent and variances based on the outcome of our very collaborative work together, which I'm proud of. Community, as I mentioned, community planning staff support the proposed consent and variances as well as the substantially in accordance condition. Staff and transportation services do not object to the proposed parking variances, and we're aware of the standard urban forestry conditions, and they're certainly acceptable to the owner. So in terms of what's changed to the plans since January 29th, there was a few minor changes that I'll just quickly run through. The west wall of the ground floor, in addition to increasing the rear yard setback, the west wall of the ground floor of the semi on Site B was moved to the east, increasing the setback on the ground floor by 0.3 meters. That was done because the swale, when it was originally proposed by Mr. Filippuzzi, without that increased setback, was really too deep, and it would make the walkway kind of uncomfortable to walk on. The second revision is the west walls of the second and third story of the semi on Site B were moved to the west by 0.3 meters to create a small overhang for weather protection. Third, the south wall of the third stories were expanded to the south by 1 meter, a modest amount. And finally, we added an easement in favor of the semi on part 2 on Site A along the walkway at the rear of Part 1, which is the existing apartment building property, and that is and that easement and we provided the revised draft R plan showing the easement to the committee with the resubmission materials. That easement is proposed to allow garbage bins to be stored at the rear of the semi on Site A and wheeled to the curb on collection day. And I believe that additional easement will allow for better streetscape, as the bins won't have to be stored, kept at the front of the house. And the revisions I've just run through have led to modest changes to the variances since January 2020, and I can certainly run through these modest changes to the variance if you'd like.
You have about 30 seconds left, so make up your own mind. You may wish to wrap up.
Okay, I'll just say that the FSIs have decreased significantly because since we were at the committee in January, last January, the secondary suites bylaw is now in force, and it's my understanding that the secondary suites that are on the lower level are no longer included. They're excluded from the GFA in the secondary suite. And I'll wrap it up there, and if there's any questions, I'm happy to answer them.
Thank you very much. Okay. Moderator, shall we hear from the Speaker in Opposition?
Speaker in Opposition, Siobhan Lee.
Hi.
Hi, good afternoon.
Hi, can you guys hear me? Hi, my name is Siobhan Lee, and I'm a tenant at 382 Dovercourt Road. So I'm not sure exactly how to upload documents, so let's try to verbally describe this, but my unit is on the southwest corner of the existing building.
Siobhan,
so sorry?
Siobhan, I'm just going to ask you, you may want to just speak up a touch louder. We're hearing you, but it's a little bit faint.
Okay, sorry. Is this better? I'm closer to the microphone. Is this better?
That sounds somewhat better. Yes, go ahead.
Okay. So my unit is at the southwest corner of the existing building, and my main two issues with the proposed blueprints are that if there is a section, so the building that's facing directly west is all windowed towards the back. And the separation space between this and the next building is, I believe, 5.5 meters, which is equivalent to 18 feet, which is under my understanding the 20 feet that's usually regulated between buildings that have windows. And this on top of the other variance, which is to heighten the existing height of the building above the zoning, these two combined together will definitely have a negative impact on the residents living on this side, because I'm assuming that these regulations were put into place just to be able to have the neighbor to have a minimum amount of negative impact around the surrounding neighbors, and yeah, this would have a negative impact. So I'm guessing why that's the zoning. That's why it's there to exist. These guidelines, right? So
I'm going to ask you to highlight that, please, or go over it again, because please explain why the impact is negative and what the nature of the negative impact is.
The negative the nature impact would be that there would be substantially less light, and that there should be 20 feet in between buildings with windows generally, and this is not 20 feet, it's 5.5 meters. So that in addition to the building, proposed building being higher than current zoning allows, so it's the height of the building and how close it is to the existing property. And if you can understand, there are windows that go down, so there is a ground level apartment there with a window mid-floor, and this would basically cut off all their light, and that would be a negative impact. And it would also go against current zoning laws, which is the 20 feet. So at least based on my understanding.
Please carry on.
Those are my main objections. That's why I oppose those two variances, is the 2 feet over variance of the 20 feet, and then the height of the building above zoning.
Panel members, any questions for the speaker? Hearing none, we'll return to the applicant for rebuttal. And applicant, I'll ask you specifically to address what was raised there. There's concern about reduced light as a result of the project. concerned about the height of the project.
Okay, so there was a specific comment made about windows. I'm not aware that there are windows on that on the east elevation of that new semi. I don't think there are windows there. And we're not asking. So it's my understanding. I'm having a look at the requested variances. We're not asking for a rear yard setback variance for the apartment building to remain at 382 Dovercourt Road. I believe that there's a reasonable separating distance, and planning staff agreed that separating distance between the rear wall of the apartment building to remain and the east wall of the semi on site A will be sufficient to allow for a generous amount of light to remain on the I guess it is the west wall of the apartment building to remain. And so if just moving on to the height issue, we spent a lot of time working out the height issue with planning staff. I believe that the heights shown are reasonable, provide a reasonable transition in height from the apartment building at 382 Dovercourt Road to the houses to the west. We've set the third stories of the proposed semis back from the front and rear walls of the buildings, which reduces the impact of this very, I believe, modest 0.45 meter height variance. I believe it's when you look at it in context in terms of the transition from the apartment building, and you can see it, I think, better on the section. The transition from the apartment building on Dovercourt to the proposed semis to the houses to the west. I believe that that's an appropriate transition in height. And we're only again asking for a very modest 0.45 meter height variance, which is really kind of modest in context.
Thank you. Panel members, questions for the applicant, please. Mr. Salomon.
My question relates to parking. What kind of parking will be provided to the apartment building, and then also how, if any, parking is being provided for the two semis?
So right now we're showing one car share space at the to the rear of the existing apartment building, so that car share space wasn't actually included in the parking provided for the apartment building because it's not specifically available to the for the apartment building, but it will be there. It's my understanding the tenants in the building are generally speaking don't own automobiles. Nobody in the building today uses parking, uses that parking lot. It's not the parking spaces at the rear of the building are not leased. They're not used by the apartment building tenants. We've provided, and so there's one car share parking space proposed at the rear of the apartment building, and there's no parking proposed for the semis. We retained a transportation engineer. The report is on file. He concluded that the proposed car share space and bicycle parking spaces for the apartment building are sufficient for the tenants, the existing building there. And the transportation engineer, in terms of the semis, also concluded that the proposal, the proposed semis are in a neighborhood that is very walkable, very bikeable, very well served by public transit. And it's likely that these attributes will appeal to people who want to live in the city, but don't own or want to own a private automobile. Transportation services staff were on board with our proposal, and our transportation engineer concluded that the proposal with respect to parking is appropriate.
When I look at the two houses immediately adjacent to the surface parking lot on the side street, you've got those two detached houses, and they each have a driveway, and it appears there's two cars parked in each of those driveways. So I'm wondering, how do you feel that for the semis that people living there will not have a vehicle?
Well, I believe that, again, that these houses will appeal to the many, many people of this city who want to live in great locations like this, but don't own a car. You know, again, the property, the area is very well served by public transit. Many people in the neighborhood, you know, don't own cars and don't want to own cars, and they bike and walk and, you know, use active modes of transportation. And, you know, in terms of the car here, you know, I think it's probably better to not have a car kind of in the boulevard, in the front yard. I think it'll provide for a much nicer streetscape than if we were to provide parking, you know, at the front of the building, you know, in the front yard, or some other arrangement. I think what we proposed here is a reasonable housing option in context. And I think the proposal would be made worse by putting parking in front of the building.
Thank you. Further questions, panel? Now, Madam Deputy Secretary Treasurer, on this application, we have the consent and the three separate parts. How shall we deal with approval or with decisions on these? Can we did them as one, or are they?
You can, it's always preferable that you do one motion but to also note that there are conditions related to the various pieces of the application. If agents have reviewed their files properly at this point, they'll know which conditions would be applied, but for the record, it's important to just note those. So if you were leaning towards an approval, the consent would be approved along with variance or urban forestry condition number 3. Item 33C, Part 2 would be urban forestry 1 and 2, plus tied to plans August 6th. And item 33D, Part 3 would be tied to urban forestry conditions 1, 2, and 3, and also to the plans dated August 6th. As I understand it, I don't believe there's anything else unless the committee members have other conditions they wanted to include.
Thanks for that very much. If I may I go back to, you said that, just to get those down, the plans that were dated, related to number 3, were dated August?
August 6th.
August 6th. Yeah. And the consent?
The conditions apply to the new dwellings. The Part 1 is the existing building, so there are no conditions with that.
Part 1 has 0. And the consent there was something related to the consent?
The regular consent conditions, plus if you approve, there'll be an urban forestry condition number 3 requiring them to plant trees or pay for the price of planting city trees. That's generally what that condition is for.
Very good. Okay. Okay then, panel. If there are no further questions for the applicant, then we could take the application into committee for discussion, for a motion. So we're now in committee.
Mr. Chairman, I'd just like to compliment the applicant on the collaboration with the neighbors. I think the resolution of those problems is quite substantial, and I think that the changes that were made are in many cases clever and very much in the public good. Of particular note is the easement that's going to allow the storage of garbage containers behind the buildings rather than on the street frontage, which is so often the case with this kind of development. The street becomes littered with garbage containers, and they've thought that through. They've provided an easement so that won't be the case in this particular location. So I would be remiss if I didn't extend my congratulations to the applicant. I think he's done an admirable job here.
Thank you.
My comments are that I like what's being proposed, but I have concerns with the issue of parking in that they're essentially removing a surface parking lot, not even maintaining any remaining parking for the existing apartment building, and that there's no parking that's being provided for the semis. And I think what will result will be on-street parking issues in the community.
I hear you on that one, I guess, but my own thought is that I am persuaded by the argument that the area is so conducive to walking that that exacerbating a problem of parking will not take place. That's just my thought. That I think in the application it describes this as a walker's paradise, and that struck me as being reasonable. Mr. Chang, any thoughts?
No further comment. I agree with Mr. Neville, and I have a feeling that people living in this area will just have to adapt and not to buy a car. I guess that's an option living in the city.
Mr. Chairman, the only other thing perhaps to mention is the objector talked about windows on the side of the semi, and like the applicant, I went back and checked the drawings, and I don't see any windows there that would be a problem either. So perhaps that was a misunderstanding reading the plans, but it looks as though one of her areas of concern needn't be an area of concern because it doesn't appear that there are windows in that location.
Right, good that you investigated that. Okay, in that case, I will look to panel for a motion, please.
Mr. Chairman, I also share Mr. Solomon's concern of parking. I do think, however, this particular area is one of those areas in the city where you basically know that there's limited parking, and you, as Mr. Chen said, you accommodate that, or you live in an area that has more parking. So I think that's a valid concern, but in this particular area, I think it's perhaps not as serious as in many other areas. Having said that, I'd like to move approval of the consent application, subject to the standard consent conditions and forestry condition number 3. The variances for, I think it's part 2, subject to forestry conditions 1 and 2, and the variances for part 3, subject to forestry conditions 1, 2, and 3.
And tying it to the plans of August 6th?
Yes, please.
So motion before the panel. Is there a second to Mr. Nipfel's motion? It is seconded by Mr. Chang. So panel has a motion before it to approve the application as stated by Mr. Nipfel, and the consent and the 3 parts on the variances. Show of hands, please, all those in favor. And those in opposition, show of hands, please. Opposed, Mr. Salomon. The result is that the motion is carried, and the application, the consent, and the 3 parts are approved as stated by Mr. Nipfel. And with that, the panel wraps up its agenda for this afternoon and for today. And the hearing is thereby terminated at 4:33 p.m. Thanks to panel members for their very, very good focus on the applications today.
Thank you. Thank you, everybody. Have a nice
Thanks.
evening. It's nice to
Keep
see the
well.
sunshine
Thank you.
coming through your window there, Aaron.
Yeah, thank you. So
I
I'll see you next
I
week.
have to say,
Huh?
I have to say with the sun, Aaron, when you put your hand up, you
Yeah.
look like God because the sun comes through your hand.
I'm at the attic. I didn't get the blinds here. I didn't expect it. So
Enjoy your day.
okay.
Bye.
So see you next year. Bye bye.